Citizen Review Board is now called to order. If you will, please rise for the Pledge of Allegiance. I pledge allegiance to the flag of the United States of America and to the republic for which it stands, one nation, under God, indivisible, with liberty and justice for all. Thank you. Madam Clerk, will you please conduct the roll call?
Banks, Collins, Simmons,
Present.
Tamayo,
Present.
Reyes,
Here.
Guy,
Here.
Akil,
Here.
Blair,
Present.
and Ingandala.
Present.
Let the record show that all members of the Citizen Review Board are present, with the exception for Reverend Banks and Hodges. The meeting is being conducted at the Old City Hall, 315 East Kennedy Street, with safety measures and social distancing between the members of the board. This meeting is being live streamed to a larger room here at Old City Hall. This meeting has been noticed by posting on the Tampa Police Department website, posting at the Old City Hall, and on the city electronic calendar. This meeting is being conducted live with an in-person quorum present, with the option of participation through in-person kiosk, voicemail, or mail. The public and citizens of the city of Tampa will be able to watch, listen, or view this meeting by cable TV, internet, or by in-person live stream here at Old City Hall. Use of masks and social distancing inside Old City Hall are required. All written or voicemail comments must have been received no later than 24 hours prior to the meeting in order to be made part of the official record of the meeting. Written comments may not exceed 400 words, and live and voicemail comments may not exceed 3 minutes in length. Recorded and live public comment will be heard at the start of the meeting. Voicemail comments will be played during the public comment session of the meeting and become part of the permanent record of the meeting. Written comments will be distributed to the board and will also be included in the permanent record of the meeting as well. All public comments timely received will be afforded equal consideration as the public comments were made in person. At this time, Vice Chair Ms. Guy will read the meeting guidelines.
Thank you. Please silence all electronic devices. The duties and responsibilities of the Citizens Review Board are to review completed department investigations involving use of force and cases of importance and interest to the community or the city. Determine whether the disposition of reviewed cases was consistent with department policies and procedures. Review matters of importance or interest and make recommendations regarding the handling of these matters. Determine whether any revisions or additions to department policy and procedures are appropriate in reviewing matters of or importance or interest, and reporting findings and recommendations to the mayor and chief of police. Cases that are brought before the Citizens Review Board are closed internal affairs cases that have been investigated and brought to the police chief for disposition. It is the Citizen Review Board's job to review the cases and render an opinion as to whether the investigation was done according to department policies and procedures. The Citizens Review Board members are provided the investigative files in advance of the meetings. The Citizens Review Board will hear from the department whenever matters of interest or importance are requested for review by the board or the department. As will be further discussed by the chair, members of the public will have an opportunity to address the Citizens Review Board during the public comment portion of the meeting. The coordinator for the board is Captain Kevin Schulmisters. Any person who wishes to make a complaint concerning a matter which may be considered by the Professional Standards Bureau, it's hard to talk with this mask on, should see Captain Schulmisters for information on how to file a complaint. The chair is responsible for maintaining an appropriate business-like decorum during the meeting. The board should not discuss matters where the city or the department may likely be a party in litigation. The public comment portion of the meeting is coming up early on the agenda, so if you wish to speak, Please line up at the kiosk now as you can be called in order. Please maintain social distancing and wear your masks.
Thank you, Ms. Guy. Also, Madam Secretary, let the record show that all members of the Citizen Review Board are present with the exception of Reverend Banks and Carolyn Collins. Well, now we'll continue with the agenda with the approval of the minutes. The minutes have been provided to all members in advance. We need to approve the minutes from the February 23rd, 2021 meeting. Do we have a motion?
So moved. Second.
Board member Darrell Reeves has made the motion to approve the minutes. Board member Lincoln Tamayo has seconded the motion. Any discussion? All in favor say aye.
Aye.
All opposed say no. The motion passes. We'll now continue. Before we move on to the public comment portion of the meeting, I'd like to take this time to welcome. Let the record show Carolyn Collins is present. I'd like to take this time out to formally accept the duties and responsibility as continuing to serve this board as chairman. It's been a pleasure and an easy task working with such talented, unbiased individuals. This group reflects the diversity of the city of Tampa, and we have participated and overcame many challenges and in our past, and I applaud the courage and the strength of those who remain on the board and also those new on the board to ensure that this service satisfies a greater city, and let us just continue the great work. So thank you. We now move on to the public comment section of the meeting. Do we have any participants signed up for the public comment portion? Public comment rules are...
Chair, can we see if anybody is down at the kiosk downstairs, please?
Okay.
I would ask, I think our kiosk can be fed through here and we can see if anyone's down there. Anybody down there?
Okay.
Chair, Captain Kevin Schoolmeisters went to check, and there's nobody at the kiosk downstairs to be broadcast through here.
Okay. That would close the public comment portion of the agenda.
Chair Keel, I would just like to make a comment on behalf of the Citizens Review Board, just to publicly acknowledge Officer Jesse Madsen and his heroism and selfless service to our citizens in the city of Tampa. Truly a hero.
Good job.
Thank you, Mr. Tamayo. At this time, we'll continue with the agenda. However, as chair, I would like
Chair,
to...
I'm sorry. I apologize. There was nobody at the kiosk downstairs, but we did receive 2 audio calls.
Okay.
That I didn't
Okay, we will.
Sorry for the confusion, but we do need to play the 2 audio files.
Okay, we will reopen the public comment portion of the agenda to hear the audio version of the public comment, if you will. Continue, please.
Hi, my name is Tatiana Morales, and I live in the university area of town. I'm calling to express my support for the ACLU-ASK, or Citizens Review Board, by allowing independent counsel and by allowing more powers to the Citizens Review Board. The Citizens Review Board will actually be able to hold the police department to an accountability that would allow the police department to run and be more accountable to the community, to the city, and to everyone that requires it. Over the last summer, there were so many events of lack of police accountability and constant showing of lack of police accountability, showing from officers not wearing their badges, from covering their badge numbers, from not giving information when requested, for not actually serving the community when requested, and leading into dangerous acts such as what's happening to Jane Moore and the doxing that's happening to other parts of other citizens. So I'm asking for the ACLU-ASK so we can hold our police department accountable to be a better police department. There are many people that have called in to ask for the maximum authority allowed by law, allowed by illegal practice, and TPD has frankly broken a lot of trust of a lot of people in the community. And if we say that we are to serve the community and to help the community, we need to be accountable to the community. It is the least you can do as Citizens Review Board members, and we are all calling to demand better out of the Tampa Police Department and out of you Citizens Review Board members. Thank you for your time, and please make the Tampa Police Department accountable to the community.
Thank you for the call.
There's one more call, Chair.
My name is Tasia Stagg, address 2905 East Okara Road. I moved to the Laurel Terrace neighborhood of North Tampa to be near campus while attending medical school at USF. I'm board certified in a specialty called Public Health and General Preventive Medicine. I further trained in healthcare quality and patient safety. Personal integrity, conscientiousness, and putting others' needs ahead of my own are values I learned from my parents. I am single and live alone. For about 2 years, I've been the victim of bullying by the family next door. When I say bullying, I mean harassment, stalking, and defamation. I fear for my safety because of that family's behavior, and now because of the conduct of Tampa Police, of every rank I've encountered, which is up to captain. On a fraction of the occasions I've particularly feared for my safety, I called the police for help, and they have invariably made the situation worse. Every call has been due to the delusions of the heavy alcohol users next door. I want to share with you 2 quotes that explain the flaws, some would say features, that have resulted in police choosing the wrong side against me. When faced with a difficult question, we often answer an easier one instead, usually without noticing the substitution. I can only guess what question police are substituting for which party is the victim. But when I noticed that a corporal didn't even know the scope of TPD's implicit bias training, he stated that bias could not be at play in his treatment of me because bias involves race and only race. I was surprised that the resulting investigation gave no specifics, only a finding of unprofessional conduct. So there's no written record of his objective knowledge deficiency, and his discipline was limited to oral admonishment rather than including remedial implicit bias training. This brings me to the second quotation. Every system is perfectly designed to get the results it gets. I have been protecting myself from COVID exposure with no willing exceptions since distancing recommendations were first issued. In multiple encounters with Tampa Police, they have unnecessarily violated distancing recommendations. Most recently, on January 30th, my rights were violated and I was falsely accused of trespassing by a poorly behaving Tampa PD sergeant, in spite of video evidence to the contrary. He had gratuitously violated distancing recommendations during our interaction and later stated that he wanted to take me into custody. I protected myself from COVID exposure. He stated that a warrant would be issued for my arrest. This would be a hilarious lie, and I would be eager to get him punished except for 3 things. My dog will suffer, police don't get meaningfully disciplined, and I disagree with the police about wanting me to be exposed to a deadly virus. I've read TPD's mission statement, and I'm appalled at their lack of regard for truth, health, safety, accountability, and quality. I've limited my comment to 3 minutes.
Thank you for the call. Any board members wish to address any of the two calls heard?
I'd like to make just one comment.
Go ahead, Carolyn Collins.
I can appreciate and thank each of those individuals for making the calls. I heard the first one and the second one, but for the second one, it seems like that's a complaint that needs to be filed, and I'm not sure if that party is listening, if she's already filed a complaint with District 1, 2, or 3, which is closest to her community. I heard she attend USF, but I'm not too sure if what area she live in. I heard the area, but I don't know which district would be best. But I would recommend that if she's not filed a complaint, that she would file a complaint and have them address that. That then would afford us the opportunity, once that investigation is completed, to come before the board. I don't want her to tell us and then we do nothing. So I just want to make sure that she knows that the process for us is to file that in a written complaint, and it will be investigated, and then we would ask our support team that if that complaint is filed from this young lady, that please make sure that's one of the ones that come before us, as we've done in the past.
Thank you, Carolyn Collins.
Do we have a record of a complaint having been filed by the second caller?
Good evening, Captain Schoolmeisters, Professional Standards Bureau. Listening to that, if she had spoken to a captain, she probably did file a complaint.
Okay.
It was probably her up through the chain of command. But there's no way unless we look into our AIM software to for sure. But I'll check with, actually it should be District 2, I'll check with them tomorrow and then get back with you to see. But if she spoke to a captain, my guess is yes, she filed a complaint.
Okay, and if she has filed a written complaint, once the investigation is complete, as we've done in the past, we would ask that that be a case that be notified to our chair, our vice chair, who actually pull the cases, and make sure that after the investigation, that case is brought back to us as one of our cases.
Absolutely.
Thank you.
Thank you. Continuing with the agenda, typically we will continue with item F, review of investigations. I understand that we have a representative from the city attorney's office, so I propose that we continue with item G, and we'll follow up with item F, review of investigations, to ensure we don't keep our guests waiting. So at this time, we will continue with item G on the agenda. We will now move to Community and Tampa Police Department matters. And tonight, we are welcome with the City Attorney's Office, who has invited to speak to the board about legal counsel on behalf of the board. If you will, please approach the podium.
Yes, sir.
Thank you.
Good evening. My name is Ursula Richardson. I'm Chief Assistant City Attorney with the City Attorney's Office. And I'm here to essentially present to you and also answer any questions you may have about the ordinance changes that have been proposed in this case. I won't go over every single thing that's happened in the case, but I did want to give you some background since you haven't had the opportunity of a presentation from the City Attorney's Office. But the background of this case is that this case started in June 4th, not the case, but I'm sorry. The changes started rolling on June 4th, 2020, when Councilman Orlando Goods made a motion. If it's okay, can I remove my mask?
Yes.
I'm suffering here, okay. Councilman Orlando Goods made a motion essentially asking in response to some of the people that were complaining at city council meetings about the conduct of demonstrations. In response to that, he made a motion asking for the administration to consider that the CRB be involved in the hiring process. And that is kind of what started the ball rolling for all of the different changes. That motion was made on June 4th, 2020, and the next workshop, July 30th, is where essentially between June 4th and July 30th, several people weighed in, and several organizations weighed in on things that they proposed, as well as city councilmen themselves making recommendations for proposed changes to the ordinance. Those changes were all incorporated to the extent that they could be incorporated, and a first draft was presented to the city council on July 30th at its workshop. At that particular workshop, there was still a push for certain powers and duties. Subpoena power was one of the issues. Independent counsel was one of the issues. Independent staff was one of the issues. And one other thing that I can't remember right at this very second, but those are things that were coming up from other organizations. I believe the ACLU was mentioned on the phone call, and that was one of the organizations that was pushing for certain changes. After the July 30th workshop, there was a city council motion essentially saying, to the extent that changes could be incorporated as they were being requested, to incorporate those changes into the ordinance, and if the changes could not be made, to present essentially a legal memorandum to the city council explaining the reason why those could not be done. There was a 24-page memorandum that was submitted to the city council before its workshop on September 24th, which set forth things that could not be incorporated into the ordinance. And those things were independent staff, budget, outside counsel, and subpoena power and investigative authority. Those were the things that the memo addressed that could not, in the city attorney's opinion, be legally incorporated into the ordinance as requested. From your perspective, the independent counsel issue is a charter issue. And not to belabor it, but the charter obviously is the constitution for the city of Tampa. It is our implementing document, and it controls what powers, what authorities, what happens within the city. And just for anybody who is a buff, it's City Charter Section 5.018. It is the portion of the charter that deals with the legal department and the powers of the city attorney. That portion of the charter says that the city attorney has charge and control of all the legal business of the city and is the legal advisor to the mayor, city council, departments, and boards of city government. The city attorney shall be the final official legal representative for the city. And just so that I can clarify for you, every single board within the city of Tampa and committees are represented by an assistant city attorney in some capacity. The only two places where that isn't true is where the city attorney has a direct conflict. That would be the Civil Service Board, where the city is presenting a case essentially before that board in order to defend an employment action that it's taken, and so we cannot also give advice to the board that we're presenting to. That board does have what's called conflict counsel, and that conflict counsel is not independent in the sense that that counsel is hired, retained, and paid through the city attorney's budget. The other portion where, the other place where there is conflict counsel is the Code Enforcement Board. Again, the city is prosecuting violations of its code. It cannot also give advice to the board and or the special magistrate. So in that instance, there is also conflict counsel, and that conflict counsel is not independent in the sense that that conflict counsel is retained by, its invoices are paid through and by the city attorney's office. So based on the city's charter or the city's constitution, there is no concept of independent counsel for any board within the city of Tampa. The only other exception to that within our charter is the attorney for the city council, which is provided for in the charter. He is independent counsel to the city council, but again, that's in our constitution, that he will be the advisor for the city council, but the official and final legal position of this city comes from the city attorney according to our constitution. After the September 24th meeting where we put forth the memorandum that set forth why different changes could not be made as a part of the ordinance, the ACLU, I believe, spoke on that day. The PBA spoke on that day. There were also comments from different council people. I believe your chair was also present for that particular meeting. And after that, we were asked to go back and consider more things from the ACLU. We were also asked to consider comments from the PBA, which obviously were important because it does affect the police officers. And we were also asked to consider different recommendations made by Councilman Dingfelder. At the September 24th workshop, Councilman Dingfelder threw out as a suggestion that perhaps someone within the city attorney's office who was not affiliated with the police department could be a part of your legal team or your legal advisor. And in the ordinance, that is what you have before you today. I believe Mr. Schmidt provided it to you on February 23rd. The proposal in that ordinance is that a city attorney who is not with the police department, would be your legal advisor, separate and apart from Mr. Smith, who would be here for the purposes of the police department. And that person would essentially be your advisor. And in the event that a conflict arose between whatever advice you were receiving from the city attorney's office or the legal advisor, the city attorney agreed that she would retain conflict counsel, which means she would also be paying for conflict counsel, to resolve whatever potential conflict would arise. That was where we were in September, from September to November, so we did incorporate those changes in November. A workshop was scheduled for November 19th, but then because of the continuing conversations around different issues, and not just the legal counsel issue, but other issues, for instance, the apportionment of appointments is one of the issues that has been a sticking point in us trying to get a resolution for this ordinance. But November 19th workshop was then continued to February 25th, and that is the workshop that just passed. The latest draft that Mr. Smith gave you on 223 essentially is where we are at this moment, but after the workshop on February 25th, we've been asked to do a few tweaks. There's still some issues to be worked out there, but the latest round of tweaks are essentially some clarification that you can still review cases, because right now that your draft ordinance says that you would be able to expand the kind of cases that you could review. I believe you're currently just reviewing excessive force claims or use of force claims. And this ordinance expands and gives you the ability to see cases where an officer has been demoted, terminated, or suspended, which could be for any number of reasons, turning off the body camera or falsifying the time, but it does open up the kind of cases. There was some confusion at the last meeting about whether or not that precluded you from looking at cases where discipline was not imposed, and that is not the case. You can still review use of force cases where no discipline was imposed under your current duties, and also under your matters of interest to the community or the department. You still have the opportunity to look at any case, just like you just did a few minutes ago for the young lady who called in on the comments. You can look at any case that you choose to look at. So we are clarifying that within the ordinance to specifically write that that has not been taken away from you, and you'll still be able to do that. The other issue that was a sticking point at this last city council workshop was, I believe it was Councilman Goods might have brought up this issue of misdemeanor arrest, essentially clarifying that if a person gets a misdemeanor while actually serving on the board, that the person would need to take a leave of absence to resolve that issue before service could continue. And I believe his thought process was essentially, if you're a city employee and you get arrested, the city does have a provision that you must essentially not be employed for some portion of time until you resolve that particular arrest. And so I think that is his thought process. So we're supposed to resolve that. There's still an issue of the apportionment of the board members. City Council had suggestions at the last meeting, essentially asking that the majority of appointments be to the City Council, and that the mayor should have at least 4, and then also have the NAAC appointment as well as a part of her appointments, but that they would have the majority of the votes. And the very last thing that is still an issue is, you all know that your creation in 2015 probably was very controversial. It's probably an understatement to say that it was controversial, but one of the things that City Council wanted to make sure that this 2021 ordinance was going to completely supersede the 2015 ordinance in your creation. So there is still some issues to be worked out, but where City Council is at this point is that the next meeting has been set for May 20th. We've been asked to bring back a draft for first reading. Just for your edification, there have been many, many hours of conversations, meetings, review of documents, and all kind of things in order to try and make this the most balanced ordinance that we could possibly make, with all the different comments, suggestions, revisions, changes that have been coming at the city attorney's office. And we feel like we have come up with a balanced product at this point. We feel like we have gone over and beyond to try and depoliticize the issue and just look at what's best for the city, what's best for the board. Just so that you all know, I know that you have the ordinance, but as a part of the draft ordinance highlights, again, it expands your cases to review. It would get you involved in hiring, the hiring panel, and also critiquing hiring for police officers. It also proposes a complaint tracking system. So from the very beginning, obviously there are some redactions we'd have to make because of the Officer's Bill of Rights. But when a complaint is made to the department, we'd anticipate that monthly you would receive a list letting you know, essentially with information redacted, that a complaint's here, this is its status. So again, you still have the ability to see any complaint, obviously with the important legal information out of the public sphere until it's appropriate, and then track whatever that is. So if there is a complaint related to a shooting, it may just say shooting, it won't have the identification of any information that might divulge the underlying details, but if it's something you thought you might be interested in, you'd be able to track it. The other purpose of the complaint tracking system is to ensure that you and the public know that complaints don't drop through the cracks. When a complaint is made, TPD has a well-oiled system and professional standards that will follow those complaints, and or a well-oiled system in the districts themselves to make sure that complaints are processed and they are followed through on. The other contemplated changes, and I'm not hitting every one of them, but just essentially the highlights, is that we would anticipate a requirement for a community survey every 2 years. The City Council and others did find it helpful, the survey that you did in 2018 and the information that it revealed, and believe that it's important to continue to get the community to give input about its position or its feelings about TPD, what they need, what they would like to see, and things like that. There's also community engagement. I believe it was a City Council member who made this suggestion, but that your meeting should go essentially leave the house, if you will, and actually go out into the community at least 4 of the districts. And that way the community may have an opportunity to participate if it's directly in their geographical location. And then we also anticipate that they will build a website, that our TNI folks, our communications and marketing people will build a website that will also increase your visibility, which means in the same way that City Council has a website that sets your meetings, your agendas, important information, also information to allow people to know how to make a complaint within the police department or to the police department, that would be something we'd anticipate would be on your website. Even your annual reports, that would be something that you could post and the community could easily access that and they wouldn't have to search for it. We also have built in an annual live report to City Council, and that means that your chair would have to appear, whoever that chair may be, would have to appear at least once a year before the City Council to present your annual report. But it's your opportunity at that point to talk about what's working, what's not working, and any suggested revisions to the ordinance itself that you would make to City Council to tell them essentially what's been happening in the year where you've been working. And it wouldn't be a situation where there's visibility on you for a short period of time because something's happening and then it kind of drops off. Every single year, there will be that attention on what you do, your duties, and how important you are to the City of Tampa, and for you to convey that information. There would also be increased training. There is in your new draft ordinance, of course, if you're going to participate in the hiring process, then you have to be educated about what requirements there are for hiring police officers. The state of Florida has specific criteria that must be met no matter what the agency. And then, of course, our individual agency has even more, not restrictive, but it's essentially increased qualifications for a person to be able to work for Tampa Police Department. But that would be something you'd learn in a training about the hiring process. And just so I don't forget, the person who was anticipated to perhaps be your counsel that is a city attorney but is not affiliated with the police department. His name is Mr. Carl Brody. He was introduced at the last city council meeting to City Council. Mr. Brody has been an attorney for almost 30 years, and he was with Pinellas County Attorney's Office, and recently joined our office in November of 2020. And Mr. Brody is, well-versed in representing boards, obviously in government work, since he's spent, I believe he's also board certified in city, county, and local government. So Mr. Brody would be a great addition, not pushing anybody on you or making any suggestions, just letting you know that he was introduced to the City Council at the last workshop. And so he is who the city attorney contemplates would be your advisor who's not associated with the police department. Let's see, and if after May 20th is the next city council date, And if after that, the first reading, the ordinance passes first reading, what we anticipate as the next steps is that the ordinance wouldn't go into effect until October 1st, and we're asking for some lead time before the ordinance is effective, simply because we need to develop a schedule for the appointment of additional members, because you're currently, I believe it's 9 and 2 alternates, but the anticipated increase is that you will have 11 total members. We need to develop a schedule for community meetings and identify locations for those meetings. Develop a training curriculum for your first year on hiring, discipline, and new SOPs. Establish the TPD interview panel, because right now, the panel that is proposed does not exist, but it is something that they would anticipate putting together in order to allow the CRB to participate in that board. So it would we would need to establish a TPD interview panel and also the rotation of your members, because the proposed ordinance contemplates that each one of you would take a rotation so that you get the opportunity to experience what happens during a hiring session for the Tampa Police Department. We would need to establish the monthly complaint reporting and tracking system. Again, it is proposed, but it does not currently exist. And we would need to create a process for intake of complaints that might be filed with the CRB itself, and also create the website and publish the links that I spoke about earlier. So that's where we anticipate where we may be headed in this. But obviously, I'm here as a representative to speak to you as a collective. I don't want to just make a presentation. If there are suggestions or comments that in this process you would like for us to consider, we certainly want to hear from you. Obviously, since this is published, the City Council also hears from you, and you don't have to just limit your comments to today. If you have strong feelings about something that you feel like you need as a board, certainly reaching out to the City Attorney's Office is important, but also reaching out to the City Council members themselves is extremely important, because they are in some ways driving the train when it comes to the ordinance. And so I would end my presentation, but I make myself available for any comments or questions you may have.
Attorney Richardson, what is the city attorney's position on expanding reviewable cases and the CRBs being involved in the hiring of officers?
We as the attorneys don't take a position. I can tell you that the administration, control of the police department, according to the charter, it falls squarely within the mayor's wheelhouse. But the mayor has conceded that she is willing to allow the CRB to participate on the panel, and the chief of police was willing to create the panel so that the CRB could participate. So from that perspective, there is no issue. But we don't take a position on it.
But I appreciate the expansion on the answer. So the mayor's office, the chief, they're kosher with this.
Yes, sir.
Very good. Now, and as far as the city, isn't the entire city attorney's office associated with the police department, as it is with?
No, the city attorney's office, like say for instance, I'm chief assistant of the city attorney's office, but I do litigation. So to the extent that I may have to contact the police department for something I need for litigation, but I'm not the legal advisor. I don't review contracts, agreements. I don't write SOPs. I don't do any of that for the department. That would be Mr. Schmidt's wheelhouse. Each city attorney is assigned, again, there's a litigation section that only does lawsuits. And then we have city attorneys who are assigned to other departments. Mr. Brody represents the human resources. He does the Human Rights Board is a part of, he's EBO, which is, the Equal Opportunity Business office. He also takes care of that, and he has some other responsibilities, but he's not directly affiliated with the police department.
Is Attorney Schmidt's only wheelhouse the police department?
For the most part.
For the most part, okay. And I'm sure that Attorney Brody is eminently qualified. Would he be working with us in the exact same way that Attorney Schmidt has worked with us?
That's what we anticipate, but it was to, everyone on the outside has raised the specter as if there has been a conflict. Again, it's not a position we're taking, but others are pushing that, that because he is affiliated with the police department, that perhaps you're not getting the full spectrum of advice that you could get. I don't think that could be further from the truth from my own personal perspective.
And I agree with that.
But in order to at least, try to eliminate that complaint from others on the outside. It was to give the position to someone who is not internal to the police department.
Yeah, I'm just concerned with creeping redundancy of 2 attorneys and 3 attorneys doing the exact same work that we've already seen done with us and for us from a city attorney.
It's a discussion that's
Classic government.
yeah, it's a discussion that's been had, and just so that you know that there was a last motion made at the February 25th, and it was for the city council attorney along with the legal department to come back with language for the charter review, essentially language that could be put on a referendum to change the charter to add the ability, and I don't want to misspeak, so I'm going to tell you exactly what the motion was. Requested, the Martin Shelby and the legal department were requested to prepare and present a draft ordinance that would give the Citizens Review Board discretion to hire or retain independent counsel. Further, that said ordinance would be presented as a charter question for citizens. So that you know that is, even though we have a solution we believe that works, we, meaning the city attorney, that works, there's still at least some desire for there to be at least the appearance of independence. And that's why it has to be a charter question, because the way that the charter is written right now, obviously all boards, city council and the mayor are represented by the city attorney's office. And in order to make that happen, the citizens would have to vote to make that a separate entity. From our perspective, obviously the reason why the city attorney is the board representative for all these entities is because the wrong advice could subject the city to legal action, and then the city attorney would be responsible for defending the city action. And it kind of blows my mind in the way that you would hire somebody independently who could subject the city to legal action, but that they're not responsible to report to or be supervised by the city attorney. That's at least one of my concerns. I don't know if that answered your question.
Thank you.
In addition, has it been proposed what type of budget increase would this burden taxpayers in reference to having the independent counsel? I know we rely heavily on Mike Schmidt, and you mentioned earlier paid invoices and things of that nature. Will we be substituted to a limited time frame, being that now there's invoices involved and things of that nature as far as budget is concerned?
I know that one of the council members made a motion, essentially, I don't think it was successful, I don't think it passed, but it was a motion to hire outside counsel but limit the number of hours. I believe it was 10 hours a month, and also limit the pay to $150 an hour. Obviously, most attorneys who've had any experience probably could charge about $400 for their time. But they would be asking for an attorney with experience to limit that to $150 and 10 hours a month. I don't believe that request was carried by motion at the city council, but that has been floated as a suggestion that maybe someone could be hired at a reduced rate, but limit the number of hours. Just knowing what Mr. Schmidt does for you all, having been engaged in this process, I don't believe that an outside person who would probably have to rely heavily on Mr. Schmidt, by the way, would be able to limit their review and their assistance to 10 hours a month. But that's the reality.
Yes, will you will, Ms. Simmons?
Yeah, first of all, thank you so much for coming and giving us all this good information. This is really helpful. As it relates to the potential requirement for the community survey, when we did that, we had a lot of challenges getting the word out, particularly into communities that don't have as much access to technology. So I just would like to be on the record saying if that's going to be a requirement, we're going to need marketing dollars or support to, for lack of a better phrase, put feet on the street to make sure that all of the different communities are represented in the survey. Because I think we extended that deadline like 2 or 3 times, trying to make sure that it wasn't just one community that was represented. Again, you told us to share things that we want to keep in mind.
I don't think that because it's new, again, it's one of those things that'll have to be worked out in the next steps. We do have some idea of how much it cost for the last survey and the amount of work that went into it. A part of this draft ordinance that there can be no denying, this draft ordinance, the way that it currently sits, would require more work from you as a board, but it also would require extensively more work from the police department and its staff to support the new initiatives within this, within the proposed ordinance. So that would mean at some point carving out the money, the marketing, as you say, the feet on the street to try and make it happen. But I believe we could do it. We're associated right now, the department is, with Dr. Brianna, I can't remember her name right at this, Fox. Dr. Brianna Fox, who might be able to assist and guide us through the process for the next go-round. It was initially proposed that it would be every 3 years, knowing how much work would go into getting it ready. But then I believe one of the city council members asked that it be 2 years, so it was reduced to 2 years for that reason.
If you will, Dr. Collins.
Had a couple of questions, but I want to ditto our appreciation for the presentation. It was extremely thorough to the summary portion that you did, and it actually further emphasized a conversation that I was able to have in asking questions about this as well. I'm going to ask you if you can make clarity on 3 things for me if you can, and I'm going to go from the bottom up on my questions because I was hoping they were all asked.
Okay.
So I wouldn't have to ask any. But the communications with the website would be a great thing. But I think one of the questions that we've been asked last month at the meeting and had asked about previously is the communications of when our meetings are, to make sure that information is published appropriately and not just in the paper, but how do we make sure that if it's an email notification going out, if it's on the website, if we can send notices to the local churches, all churches, to other organizations, so that we make sure that because one of the things that we heard with the focus last year during the Black Lives Matter and all of the issues was nobody knew we were there, or they thought we wasn't there, or they thought we weren't doing anything. Thus, that's why many of these questions came up. But we've been here trying to get people to come, and they were not coming. And I'm not taking issue with, but I am saying that I really am concerned about how many meetings we're going to be having away from here, because that will tax the staff as well in going to get things set up for recording. We saw that over at the convention center, and we had no problem with people coming at the convention center when they wanted to come. So I think people will come if they have the information early enough, they can plan. And when you look at other boards in the city that have their regular board meetings, individuals that want to attend those board meetings, they attend. So I am kind of concerned about going in the community to have multiple meetings. If we were saying when we got our annual report that we wanted to do that in a couple of areas in the community to cover them, but that would be one of the ones that I'm concerned about, is how many meetings we would be going out and if they're really necessary, because when people wanted to come to us, they came.
I believe that was a recommendation that was made by one of the city council members, and I believe it is 4. It's 4, anticipated to be 4 meetings. I'm looking for your meeting section.
And while you're looking,
okay,
we still
so
have 3 districts, right?
it's page 5 of the draft ordinance. It's in section F2. It says at least 4 times per year the CRB meeting shall be held in a community location in each of the 4 city council single-member districts, and the respective council member for said district shall be encouraged to attend the meeting in their district. So I think it was for the purpose of, again, elevating, maybe bringing you to the people, but also so that city council can be involved in their particular district. But this particular recommendation, I have a distinct recollection that it was requested by a city council member.
So the 4 was for the council district, because what we previously done is, in particular in the areas where we live, we've gone to the 3 police districts, and we've attended meetings, and they were very well attended. But we used the police district since we was the police citizen review board.
Which you could still use the police district, and I'm not sure how the districts are exactly laid out with you could still use it as a meeting space. It's just that I think the idea was, again, to take it directly to people who may not otherwise want to catch a bus or deal with the downtown streets. and parking issues, hoping to increase community participation in your meetings because we are aware that that has been an issue. I personally have watched a lot of your meetings through the website where your meetings are posted, and I do recognize that participation is an issue, and I'm not sure if that's what the council member was recognizing
And
as well.
and I appreciate it. I just wanted to ask because we've been indicating the difficulty would be for staff, and you know, if it's the 4 with the single member districts at the city council, you know, the way they allot it, or if it's a 3 with the TPD districts, because they are core somewhat in a sense in the community, whatever. But I just wanted to.
But just so that you are aware, some of those things are things that we would anticipate happening in your next steps. Also amending your own procedures if the new ordinance is passed, amending your own procedures so that you can address that. It's been a big push about your own independence. You setting your own agenda, you picking your own cases and things like that. So if you wanted to select the location in each one of those districts, if you want to set when those meetings will occur, that will be up to you as a board to make that decision. As far as the difficulty of this, what we've changed the ordinance to say, I believe it said televised before, now I believe it just says broadcast or publish, which you know, if you need to set up a camera to broadcast, you know, to Facebook or whatever it is, that you would have the ability to do that perhaps without not so much technical assistance in order to make it happen and in those particular districts. But we did change the language for that reason to hopefully make it easier to appear in the community locations.
Okay, my other, since I'm coming up, I'm gonna come up from the bottom. The subpoena power and the legal counsel, sometimes in my mind, I think what I'm hearing from the community is they get confused. And I think the reason being with the legal counsel is I'm pleased with what we're getting from our Attorney Smith, and he actually responded to us in a very positive way, punctually, communicate with us because we can't communicate with one another if we send anything to him. He's very on it, so I know we're kind of pleased with that. But I think if there was a situation where the board had a differ, I think that's where they may have, and it seems like, and I don't want to throw good money after bad, but if there was a situation where it was a conflict, and if we had the opportunity to know that we also had that conflict, that would be well. I'm not advocating against it. At this point, I'm not advocating for it, but I think people want us to have subpoena power, and if we don't have subpoena power, they want to have legal, and I think it should be clear, even with the city council, as they pursue it, which one do you want? Because if we do not need it at the moment, but when the need exists, we need to make sure that we have whatever it is.
I think those are two different things that I have to address. The subpoena power issue seems to have been pushed by one of the organizations based on 2 agencies down in South Florida. The city of Miami has what's called a civilian investigative panel that was created back in 2001, and that was charter. That was a charter creation where the citizens of Miami decided that they wanted an independent board. So essentially they created a city department that has some independence, and part of that was their own legal counsel. Part of that was also subpoena power because they are the civilian investigative panel. That investigative panel does not take the place of the professional standards or internal affairs process because Florida law requires that the agency be the only one to do that when it comes to discipline of a police officer. But they have the ability to do a dual or parallel investigation that they can then make recommendations to the department after doing their own investigation. But that is a machine. That is a machine that comes with a budget. It's also a machine that started with a budget that was approximately $300,000 and is now currently $1.2 million a year. So because they have independent staff, because somebody has to send the subpoenas and somebody has to serve them and somebody has to ask questions of witnesses. The other board is Key West, which is also the Key West Civilian Review Board is also a charter created entity that came with, as a part of the voter referendum, the ability to have an independent attorney and also the ability to have subpoena power. Essentially pushing for subpoena power, I don't think that everybody has looked at it in the sense that pushing for subpoena power is essentially pushing for you to be an investigative panel as opposed to what you do right now. And that just having subpoena power really doesn't mean anything if there's not another machine to push that. Because again, somebody has to review, Those boards down in South Florida that have a lawyer, that lawyer can't just issue the subpoenas. It's built into the charter that that lawyer must then consult with the state attorney's office to make sure that they can issue the subpoena. And then after that, it's issued again. Service of the subpoena is an issue. Responses to the subpoena. What do you do if somebody doesn't obey your subpoena? That's a whole ball of wax that I think nobody has really given great consideration to as far as what are all the practical implications for subpoena power and what does it all mean. The legal counsel, I think they've been pushing for legal counsel in the sense that they believe that there's a conflict between Mr. Schmidt's representation and your duties as a board. But the new or the proposed ordinance does build in what you just said, which is the opportunity that if a conflict arises, that the city attorney would hire and pay a lawyer to essentially represent you in that issue and resolve that conflict for you.
Okay, and then, thank you, and I thank you so much for explaining this, because these are the kind of questions that I'm getting on the outside, and it's clear for us as a board, but I'm hoping that it's also clear for those in the community that's been asking the questions as well.
Yes, ma'am, and for the record, we have provided, from the perspective of the budget, the staff, questions to that extent. The way that our charter is currently written, we did provide in our memorandum to City Council in September explanations for why we believe those weren't viable things that could occur based on the way that our charter currently sits, and we explained that in that I believe it's a 24-page memorandum. But I think people keep saying subpoena power, subpoena power, subpoena power. One of the issues that keeps coming up is whether or not you could even issue a subpoena to police officers based on a 2017 Florida Supreme Court case. Initially, I believe City Council was of the belief that perhaps you could issue subpoenas to the officer who was not the subject of the investigation, but I think it's ultimately been concluded that that 2017 opinion precludes subpoenas issued to any police officer in the state of Florida based on the Officer's Bill of Rights. So when you're talking about subpoena power, at this point, you're talking about non-police officers or civilian witnesses, or maybe the subpoena of documents and things like that. I know that some people feel very strongly about the thought that their Ring doorbell video could be subpoenaed. There were some strong comments at some of the city council meetings about that. But that's what we would be talking about at this point is non-police witnesses for subpoenas or documents and things.
Okay, thank you. And my last question, and I hope that's beneficial. It's beneficial to me, and I hope it's beneficial to people who are asking the questions, who've been very thorough in those areas. And I'm going to go ahead and kind of indicate that I think it's beneficial because oftentimes people don't read all of that, and they hear what someone else is saying, and you're at least laying it out clearly, so that's good. And the last one is you mentioned about ACLU, NAACP, and I assume some other organizations. Can you make it clear for me, hopefully for others that are listening, exactly what you were saying about the position on the board? Is it like, are we gonna just go with one organization, or are we saying expanding the board is gonna be multiple organizations all would have a seat, or to be an option between those organizations at, like that?
No, at this point, the draft ordinance that's before you is that there will be applicants who would apply to be appointed by city council, and there would be applicants that would apply to be appointed by the mayor, and that the NAACP would be able to recommend a non-board member, so not somebody who's in the executive council for the NAACP, but one of their members could be nominated, and then of course that person would have to be vetted by either the mayor or the city council in order to be appointed. But it is only the single organization that has been chosen based on I think the how vocal they've been, and obviously the people seem to be calling for it. There has been at least the issue raised about whether or not it should be any other organization, like say for instance to switch them out and things like that. But again, that's not it's not an issue for the legal department because that's more of a policy. And again, I always try to separate. We're lawyers, so our issues are legal. Those are policy decisions, and obviously those policy decisions have to be made by the city council and the mayor. So we don't dip our toe in that if we don't have to.
Okay, let me just add this last one. NAACP, ACLU, several of the bar associations, and I'm only saying it because these are the calls that I've been getting. whether it's, I almost went a blank. But I know it was the Hispanic Bar Association, it's the Judge Bar Association that the courthouse is named after. Just a multiplicity of groups that called me and been saying the same thing and asking questions. I couldn't answer the questions, and that's why I asked you, is it going to be one group, or would it be from a plethora of groups that would have that opportunity to submit? Not looking for an answer, just ask. Go ahead.
At this point, it's just the one group that has been suggested, but obviously if you feel strongly that there should be a selection of groups that would make nominations, then obviously that's something that we would need to communicate to the city council. Because again, that's a policy issue, not a legal issue. But I'm more than happy to communicate that there are other organizations that may be interested in serving and would like the opportunity to be considered.
Okay. I was just saying JIVA. I'm sorry, I drew a blank there. But JIVA, ACLU, NAACP, the Hispanic Bar Association, whatever. All right, thank you.
If you will, Ms. Simmons, continue.
Yeah, so my question was along the lines, I just want to make sure that I understand. The NAACP board member, would that be them taking one of the mayor's slots potentially?
Yes.
Okay.
Yes.
So then my question would be, shouldn't they just, without it being slotted for the NAACP, wouldn't they just be able to decide themselves if they want to suggest that this board member apply no different than any other community member or any other organization could choose to get together in their own meeting and say, this is the person that from our organization we want to encourage to apply, without it being, you know, the mayor has, you know, say 5 slots and one of those slots is for the NAACP board member. That would be,
yeah.
I'm asking if we could make sure that that discussion is had in the May 20th meeting.
So essentially, I want to make sure that I understand what you're saying is that you want to have the opportunity for any organization to nominate someone for potential selection by the city council or the mayor, but not specifically designate a spot to the NAACP?
Yes, that's what I'm saying. I'm saying that, to Dr. Collins' point, any organization can run their own internal process to say, you know, like you said, JIVA, whomever, we want to get, you know, James, you know, Smith to apply, and then they make a recommendation. But I think that it should be more open, if that makes sense.
Okay.
I'm not saying it eloquently.
I don't think that the other spots are precluded from someone from an organization, say for instance, the Georgia.
No, I understand that. I'm
Right.
just saying not having a designated spot
Spot
for
just
one
for
particular organization. It can be an
Gotcha.
organizational spot, but not identifying who the organization is.
Okay. An organizational spot, but without identifying what the specific, okay, I got you.
At least have the conversation, at least want the dialogue.
I most certainly, we've had lots of dialogue, and I'm most certainly happy to engage in additional dialogue on this issue. Was there anything else for me, or?
Any further comments or
Thank you.
questions?
Thank you very much.
Thank you for
Thank
taking
you.
the time out to speak with the board about this important topic, and those who wish to follow up with the proposed draft on May 20th, please feel free to do so, and we'll just continue the process.
And just so that I'm clear, my dialogue with you doesn't stop here, so if you have additional comments or things you think of after reviewing the ordinance again, or suggestions or comments that you want to make, I'm open to accepting those. So is the City Attorney, Gina Grimes. We're open to accepting those, but we're also encouraging you to also bring these comments directly to the City Council as well, so that they're aware of your direct feelings, since you are serving on the board, about the potential changes to the board, to the ordinance.
Thank you.
Thank you.
We will now continue with the agenda with item F, review of investigations. The case on tonight's agenda, I selected, being that it is involved with an officer and body-worn camera As you all know, we have several presentations in reference to body-worn cameras. We also supported the grant in reference to the funding of body-worn cameras. So I challenged the board to identify any obstacles with this new system to ensure any new upgrades or any policy changes that could be recommended. So if you will, please continue. This case is PSB case number 19S-004 involving violation of SOP 609.9 body-worn camera equipment and MOR 1005 standard of conduct. Thank you, sir.
Yes, sir. Sorry about that. Good evening, ladies and gentlemen of the board. My name is Detective Jason DeGagny. I'm with the Internal Affairs Bureau of Professional Standards. Again, this is Internal Affairs case 19S-004. This was brought to the department's attention by an anonymous letter. On 7/4/2018 at approximately 2100 hours, Officer M. Garcia and Officer B. Bush responded to Oakhurst Apartments because of several subjects were shooting mortar-style fireworks at another officer in his marked police car. Once on scene, they exited the patrol car. Suddenly, an unknown suspect shot a mortar-style firework at them, just missing the officers by inches and striking their patrol car. The officers were forced to get back into their car and then were hit by another mortar-style firework. Officer Bush and Officer Garcia fled the complex and awaited other officers to arrive. Officer Bush and Officer Garcia were then dispatched to Julian Lane B. Riverfront Park in reference to additional subjects shooting fireworks at innocent parkgoers and their children. We had several 911 calls that night there. Excuse me, one sec, I'm sorry. So Officer Clayton joined up with Officer B. Bush and Officer Garcia. Officer Clayton was the only one wearing a body-worn camera back then because our program was in its infancy stages. While Officer Clayton and Officer Garcia were walking to the scene and towards an inherently dangerous situation, they engaged in conversation regarding the suspect clothing description. Officer Clayton could be heard, quote, "If they try to run, they are gonna," end quote. Officer Garcia interrupts, saying, quote, "I'm going to expletive slam his face," unquote. At this time, he is interrupted by Officer Clayton, who signals to his body-worn camera. Officer Garcia tells Officer Clayton, "You need to shut it off and turn it back on." Said those direct words. Officer Clayton complies and deactivates his body-worn camera for several seconds, then reactivates it. It is important to note that there were no one other than law enforcement in the immediate vicinity during this conversation. The investigation determined that Officer Clayton's decision to deactivate his body-worn camera during the active call to prevent unprofessional conduct from being recorded is a violation of the department's policy and constitutes a violation of the standard of conduct of manual regulations of 1005. Furthermore, Officer Garcia's arbitrary decision to ask Officer Clayton to deactivate his body-worn camera equipment during an active call to prevent his unprofessional conduct from being observed is a violation of the department's philosophy and constitutes a violation of the standard of conduct under manual regulations 1005. Now, originally, there was a question if Officer Clayton violated SOP 609.9, which has to do with the body-worn camera equipment. That SOP did state law enforcement activity needed to be recorded. So law enforcement activity was defined in that SOP as direct contact or interaction with citizens involving police authority. This includes all traffic stops, detentions, pursuits, investigations, and arrests or other matters with regard for potential confrontation. Since none of these applied at the time, that violation was not sustained. It's also important to note that we have updated that policy regarding our body-worn cameras. So now officers must activate their cameras when dispatched to a call, and they cannot deactivate that camera until that call is complete. The actual, what they ended up getting for that, both officers did receive an oral admonishment. And since this violation, they have not had, each officer has not had any other type of, this type of violation before regarding standard of conduct. Does anyone have any questions for me?
Detective Gagne,
Yes,
so there were no one witnessed the conversation or the hand signals between officers?
No, sir. There were 3 officers there, present at the time. No citizens or witnesses actually observed that.
But an anonymous letter was sent to
Yes.
the police department?
Yes, several months down the road.
But
Again-
there were no witnesses? An anonymous letter is sent to the police department?
Well, there was an arrest made, so in this purely speculation, could be somebody from the state attorney's office. I don't know that for sure, but it was several months down the road.
Well, an arrest was made, but
Yes.
Officer Clayton had clearly turned his camera on again
Yes,
before that arrest was made. The camera was on during the arrest.
yes.
So I'm kind of confused.
How the anonymous complaint
Yeah,
came.
I mean, so-
Well, the recordings are evidence, and they're going to be tagged as evidence. And if an arrest is made in a situation, which there was, additionally, eventually, a few minutes later, all of those tapes are evidence. So that evidence was presented to the state attorney's office. Again, purely speculation. It could have been reviewed by one of them and then reported to us.
Okay, and when reference is made that it was tagged inappropriately, what exactly does that mean?
That one, I don't know 100% for sure, but an officer has a responsibility to tag the video with the exact case number, which sometimes officers will mistakenly put the wrong numbers or whatever, or classify the event as something else. We have like 19 different classifications and names of what type of offense it is. And therefore, I don't know exactly what they labeled it, but apparently they might have labeled it wrong on here, and that was a violation.
Okay, so that's, for example, this evidence ID number that's on this Axon?
Yes.
Okay.
The ID number is the actual case number.
Mr. Smile,
If you
Kevin
will.
Schoolmeisters, I'm
Yes.
over the body-worn camera program. And what the system does through our RMS, our record management system, and our dispatch system, it auto tags the body-worn camera footage. So if I go to a call, if I get dispatched to a burglary, at the completion of that, my body-worn camera footage will be assigned that report number of that call I was assigned to. So what the officer did is, before they got to the call, if they shut it off and then turn it back on, then it's gonna get auto-tagged to the call where they made the arrest. At the time, all our footage, the state attorney could see, so anybody going into that system could look at that officer and then see what other body-worn camera footage that he's recorded that day or before, and then that's probably, I would guess, how they found that, how this is
So
done.
if I may, in this Axon table, are we talking about those 2 bottom cases, the one that happened at 9:27 and then again at 9:29?
I don't see that. I believe you're probably looking at the audit report, which is,
I believe that's what it is, right?
okay.
Is Joseph Sustek, is he a TPD employee?
He was an internal affairs investigator at the time when this case was open. You're probably
Okay.
looking at the audit trail. Anybody
Yes.
ever views a camera footage, it's recorded.
Okay.
So if I look at it, it'll say Schoolmeisters on it, He was the eye investigator that originally investigated it, so he would be,
okay,
his name, if you looked at the video, his name
Sure.
would be attached to that video.
So this is the audit trail, so can we assume then that that first incident at 9:27 and 25 seconds is when they first approached, and apparently Officer Clayton hears Officer Garcia say, "Turn off the camera," and then it's turned off, and then we go to the second incident that occurs literally 2 minutes later, which then leads to the arrest?
Yes, that's probably correct there.
Okay, and is the instruction from Officer Garcia to Officer Clayton picked up on this recording?
Yes.
So it was not erased?
No.
Okay, so, it was not erased.
No.
So again, I'm confused then. So you have a continuous recording. What the officer asked, it's not erased. They keep it on basically continuously because this is continuous. It starts at 9:27 and 25 seconds, goes for 2 minutes and 25 seconds right into the next incident. So I'm just kind of confused as to what the issue is, what the problem is.
Well, what the officer was doing, I would assume, is if you shut it off and then turn it back on, it gets assigned a different report number, or an event number. So if it's a non-event, the officers, let's say if I'm just going to lunch, I forgot to turn my camera off, and it was still recording, I turn it on, it'll be a non-event, and then that is supervisors normally don't check non-events. They will if it's random enough. But so that's what I think the intent was to do, is to make it a non-event. So an officer would or the supervisor would just look at that.
Okay, so that no one would see then that you're literally talking about the same incident because the times
that's what
are.
he was probably trying to manipulate the system.
Okay, and speaking of the system too, you've got a confluence of times here. 9:27:25 is the initial turning on of the body worn camera, and that goes for 2 minutes and 25 seconds until 9:29 and 50 seconds, and then you've got the second one starting at 9:29 and 33 seconds before the first one even ended. So you've got to wonder about a system that doesn't pick up on that kind of discrepancy between the stops and starts of the body worn camera being worn.
Well, like I said, the AxonEvidence.com records everything. Any audit trail, when that camera comes on, turns off, when it's uploaded, who views it, pretty much everything related to that video. Now, we have systems in place. We have several layers that we currently audit. We have the supervisors are required to audit so many during a month period. Then I'm also over the quality assurance part of the body-worn camera, and then we also independently from the supervisors, then we do random audits as well. Because there's just so much video footage and time it takes to view it all. We have at least 2 layers to catch things that happen.
And it was caught. Okay.
My concern is, maybe I have to catch me up to date on the equipment itself, but is there anything being implemented to eliminate future burden of officers creating determination whether the camera is on or off, which will eliminate the manipulation of body-worn cameras?
We have, our new policy now is for officers to activate their body-worn cameras as soon as they're dispatched to a call, and completely report everything until they are complete with that call.
And also, may I add, for Mr. Tamayo's question, I think what you're looking at is the body-worn camera. It always records 30 minutes or 30 seconds before the officer turns it on. So you're seeing the loop, which shows it recording in conjunction with the other one.
Thank you. Thank you for that clarification.
So if the camera is automatically activated 30 seconds prior to the activation dispatch, that means it's
There's a buffering.
continuously recording?
Yeah, so when you press the activation for the body worn camera, there's 30-second buffering, which actually captures prior to you pushing that button. It just doesn't have any sound.
Yeah, the camera's always technically recording for that 30 seconds, just the video, but not audio. So in case an officer comes across a situation where they have to take action, we'll capture the 30 seconds prior to that activity.
Now, I know we typically don't discuss different disciplinary actions, but for an oral acknowledgement that can also support tampering with evidence, that seems to be pretty substantial.
Well, it was just policy violation. It wasn't a criminal law that he was violating. It was just a policy violation.
Most concerning to me is what led Officer Clayton to ask Officer Garcia to turn off the equipment, which was the statement of aggression made. And I'm wondering if that's standard procedure for an officer to walk into a situation planning to slam somebody to the ground.
Definitely not. It's very unprofessional, obviously. However, you know, the situation of what was taking place that night, I guess his stress level was high. I can't speak for him. But the video does show multiple fireworks coming from different directions. And at the time of one of the arrests, someone shot like a bottle rocket at one of the officers too. So it's a little bit of a stressful situation, but very unprofessional.
That's why for philosophy of enforcement and standard of conduct, they were sustained.
If that situation was addressed with the officer as opposed to what he got caught doing, which was requesting the equipment being turned off.
Yes, it was addressed. I don't know to what regards, because we just go what's in the case file. This occurred in 2019.
I'd like to kind of follow up on the chair's question. I kind of had the same concern myself, and knowing that we're not delving into the administrative and the conduct piece, but that was one of the things that really jumped out at me with regards to the oral admonishment. The question that kept coming to my head was, administratively, what's the procedure for corrective action? In other words, how many oral admonishments do you get before it gets ramped up to maybe a written reprimand and then perhaps corrective action?
Well, the police department believes in progressive discipline, so it starts out as oral admonishment, it goes up to a letter of counseling, written reprimand. So it would progress if they were found, guilty of another policy violation, but they weren't. So at that point, so that's just progressive discipline.
Thank you.
Ms. Collins?
Yeah, just a couple of questions. I think most of mine have been covered. My concern with not having anything with the 609.9, if you look up under C, operations, and look at 3C and 3B that you highlighted even when we sent our report, that kind of confused me with why was 609.9 was not sustained. I also felt that way because when you look at the entire policy, and thank you for letting us know that you have changed the policy now, so it's activated, the body-worn cameras are activated when they're dispatched. But the purpose of the policy was to establish guidelines for proper use, and that wasn't a proper use. So in 609, even though I know when you say that it wasn't a more aggressive situation, but it still was not proper use, I agree with the standard of conduct, so I don't have a problem with that. It also suggests the transparency that we've talked about with TPD activity, that was not encouraging transparency because you're saying cut that camera off. I also had a note on here that I wanted to ask about what were the disciplinary actions? And I wanted to ask it again because it looked like they got a written reprimand or something to that fashion, and you're saying it was oral. That did not seem adequate, and TPD, if you look at number 10 in that policy, it says TPD, and it make reference to tampering, and cutting it off was a form of tampering. So even though we're agreeing that it was a sustained refraction to the MR 1005, if we're not going to do anything but give them an oral reprimand, it should have been, it appears that it should have also been 609.9.
Okay, yeah, in reference to the first part of your question, there was the camera was on during the physical arrest of the suspect. It was just turned off briefly. Basically, the officer was trying to cover up his unprofessionalism, and would be embarrassed if got caught for that. In regards to your other question, regarding the let's see, was it the erase and alter? None of that was done.
It wasn't erased, but it was altered, because by cutting it off, it was altered.
Yeah.
Well, at the time, it was defined with law enforcement activity. We have since changed that SOP. It's like a constant work in a breathing document. We constantly upgrade it or change it, because at that time, we only had, I believe, like 67 of the Axon 2 body-worn cameras in the field. Now we have 702. And let's say today I just looked at another change to the SOP. So monthly, we are changing it as we get more used to the technology.
And thank you, because one of the things we had asked is when policy changes occur, particularly in a situation like this, you let us know, and you certainly have let us know that this policy have changed. And we do know that after the grant that we endorsed and the city council came up with the money with that delay, that the cameras are out there. So as those changes are occurring, if we make aware of it. And I appreciate that, because that's good, because that's, I call it check and balance. You realize it needed to be placed in there, but I do think that these officers should have gotten more than an oral.
Mr. Tamayo?
Captain Schoolmeisters, this policy 3C, D, and E, this was in effect on July 4th, 2018, right?
16, correct. If you look in the right lower hand corner of the SOP,
Got it. Okay, on 16.
indicates
Okay.
March of 16.
Okay. So it's pretty unambiguous that the BWC recording system shall be utilized to gather and record the following types of events whenever possible by all officers involved. So it shall be utilized means that it also cannot be shut off. So during a potentially confrontational contact with citizens, there had already been a mortar type firework fired at a police cruiser or a police officer or officers. So the officers were responding to that. So you know that there's already a potentially confrontational situation.
Yeah, that I think it refers to the individual officer, even though it would happen to another officer. So as they're coming at that time, they weren't required to turn on their body-worn cameras. And now we have changed the policy to when they do, from, we call it call to call, you know, hands on the wheel till they're done with the call. Now they're required to. But at that time, technically you could have walked towards somebody, and before I made contact, let's say with you, then I turn it on. But not necessarily the trip to make contact with you.
Okay, but did Officer Clayton know that mortar type shells had been fired at police officers already?
That I don't know. I'd have to look at the dispatch
we just
records.
wouldn't know.
Correct.
Okay, all right, because if he did, then I would not agree with not sustaining the complaint.
The captain actually who wrote it is Tony Zambito. He used to be in my spot
Yes,
when the board
exactly.
was created. So
Yes.
when he was in the district, he's the one who wrote the letter, the disposition letter that you guys have.
And just to add insult to injury, and responses might not be necessary, but when I selected this case, it was prior to the termination of Officer Devin White, who also had an issue with a body-worn camera that was footage that was captured through a random audit. And the result was he was actually having dialogue with his wife over via mobile cell phone, but that resulted in termination. So just not to compare apples to oranges, but I just want to ensure that transparency is there and the equality is there as well.
Yes, obviously, like I discussed before, we have several layers of audits, and that was caught by his supervisor, and that is a separate violation of the city code, our B12 policy. That's what he was terminated for.
So And what's the supporting policy? I just want to try to identify the violation between an oral acknowledgement of disciplinary action and a termination factor.
Like I said, it depends on the egregiousness of the violation and what, the chief of police decides. I mean, that's the basis for it.
So when we reach the end of this discussion and we decide to accept this as we normally do, what's the protocol for us to accept the sustained reaction to MOR number 1005 and not to SOP 609.9?
If you will, Mike Schmidt, you can give us some clarification on deviating in reference to case number 19S004 involving the violation of the SOP 609.9 versus the MOR 1005 standard of conduct in reference to sustain.
Yes, sir. Good afternoon or evening, Mike Schmidt. With regards to Section 5 of your policies and procedures, review of investigations, you, at the end of the presentation, you may motion to find consistent, which shall mean the investigation and disposition of the case was consistent with the TPD policies and procedures, or motions to find inconsistent, which means the investigation and disposition of the case was not consistent with Tampa Police Department policies and procedures. Motions which pass by a majority of a vote will go on to consider whether any recommendations will be reported to the Chief of Police. CRB members will have an opportunity to discuss and vote on all motions. Written recommendations will be signed by the chair or designee and forwarded to the Chief of Police. Written dissenting opinions will be signed by those dissenting and submitted to the Chief of Police.
So the question before the board is whether we agree or disagree that the investigation and findings were consistent with department policy and procedures. If you will, Ms. Guy.
Thank you. One of the things I think that, and it's been pointed out to us, this was at the very inception of these cameras being used. Many, many policies have come and gone since then. There's a lot of things that have happened. So for us to take this and put it in this particular infraction, put it in today's environment, we probably would feel differently about it if we had looked at this the day it had happened, because these were all new. I mean, these officers obviously kind of freaked out when they realized they said something they shouldn't have said, and he turned his camera off. Bad, he shouldn't have done that. But it was all new at that point. And that is my only comment. We can say it should have been done differently in today's environment, absolutely. But when this happened, this was the brand new, and these officers were wrong. But I think we need to keep it in context that it was done at the very inception of these cameras, and the SOPs have been changed many times since then.
May I ask, is the 316 on the bottom of the policy, is that 316, and for me it's nice if I see a year, is that 316-20, 316-19, 316-21?
That number, it's March 16th when that policy was written.
Okay, what year?
2016.
March of 2016.
Correct.
March 2016.
2016.
Okay, and I wanted that to be not a year. I wanted that to be the date. And in lieu of that, that's what I'm saying. The officers who actually received the cameras, the BWC, were trained in 2016, and this policy was written in 2016. And this happened before we changed the policy to activate them. But what I'm saying is, this policy had been in effect a long time. The officers knew, and they knew they were in violation, and they had been trained for this policy prior to the current update of the policy change. My whole point is they violated a policy that they had been working with for multiple years, and they had been trained on the policy, and that's the only reason I'm saying I'm not saying they should have been terminated. but I'm saying that to just give them whatever we gave them, and I see at the end of the letter. I do agree the standard what did I write here? The standard of conduct, that was fine, but they did violate, and I cannot see saying not sustained with 609.9.
Well,
Because this wasn't something that just happened.
Well, with that, when that policy was in place, it defined as doing that during police activity. Because they were moving from point A to point B, they weren't doing police activity. We have changed that now so once they get dispatched, then it turns on. But at that time, the officers weren't required to turn it on.
So when I see the statement in there, and I won't go back and look at it now, but the statement in there where it's a pursuit in the car or a pursuit by, if they're on the ground traveling, not in the car, they are supposed to cut it on. That's what this policy said that we're looking at now. That
Well, they weren't in a pursuit, ma'am. They were walking to the call.
they was walking to the call,
Correct.
but they were looking for whoever it was. This is why he made that statement. Is that correct?
Before they got there, yes.
Okay, so he's still in pursuit. In my thought processes. Okay.
Any other further questions? Thank you, sir. Again, the question before the board is whether we agree or disagree that the investigation and findings were consistent with department policy and procedures. Can I have a motion?
I make a motion that this investigation and finding are consistent with MOR number 1005, not SOP 609.9.
So there's a motion on the floor in reference to the agreement, investigation and findings for MOR 1005, standard of conduct, but not in substantial with SOP 609.9. Do I have a second? Was that Darrell with the second? Okay, Darrell has second the motion of sustaining the MOR 105 standard of conduct, but not sustaining in reference to the violation of SOP 609.9. Any further discussion?
That's,
Mr.
let's just
Tamayo?
be clear, so that we would not agree with the decision not to sustain 609.9.
That's correct.
So this is a package deal?
It's a package deal.
Mr. Chairman, for the record, that was Blair that made the second.
I'm sorry, can you repeat?
That was Blair that made the second.
Oh, excuse me. Blair has second the motion. Any further discussion? All in favor indicate by saying aye. Aye.
Aye.
All opposed, say nay.
Nay.
Chair, I'd like to do a roll call vote because I did.
Yes, please.
Collins,
I vote yes.
Simmons,
Yes.
Tamayo,
No.
Reyes,
Yes.
Guy,
No.
Akil,
Yes.
Blair,
Yes.
Indigala.
Yes.
Motion passes.
Thank you. And the chair is open to further discussion in reference to a policy recommendation or anything of that nature that could be tabled to next month's meeting, being that there seems to be some discrepancy. The chair will be open for that.
No, there's very good procedures have been put in place to ensure that at the very beginning of a call, that the camera gets turned on and does not get turned off. That is just clear and unambiguous, and a very good move on the police department's part.
Yeah, I would agree with Mr. Tamayo. I think at the time there was ambiguity, which is why I voted the way I did, but it seems like they corrected that, because like Dr. Collins, when I read the case, I pursued it the way I took it as well, so, but I think that they've cleared that ambiguity up.
And I agree with that.
Ms. Collins?
I would clearly say that I stand by the motion, but if, as in the past, if, you know, they want to go back and take a look at 609.9 and maybe come back and bring us some explanation, but that, the way it's written, based on the time, the policy, and what occurred, I can't vote yes for this, but I can vote yes for the other part. And I recognize, appreciate, and commend the police department for the consistent modification, changing, and revision so that it'll be more current. So I'm very pleased with that, but I just, the 609.9, even if it was put in there, since it's only something tap on the hand, but.
Ms. Guy?
And I would just say that the captain did explain why the action was taken, and that in that period of time, they were on the way to the call, so they were not required to turn their camera on. Now they are required to turn their cameras on at the moment they take the call. So he did explain it, and that's why I voted the way I voted.
Great. With no further discussion, we'll continue to move to the next agenda item, the CRB staff reports or business. Is there any staff reports from our coordinator or legal?
No, sir, nothing additional from legal at this time. Or from the coordinator, sir. Thank you.
Okay. Any new business or announcements? Ms. Guy?
Thank you. I would like to add something to our next agenda. The mayor put together the Mayor's Community Task Force on Policing, and in September we had this big meeting, and I haven't heard anything since. And most of the recommendations that came out of this new task force mirrored the things that we had already done when we worked with NYU and we did our surveys. That was almost identical. Nothing was actually done with our information either. So I would like somebody from the mayor's office to come to us and go through any things that have been done since September on this Mayor's Community Task Force, because frankly, I haven't seen anything. I think the stuff that came out of it was excellent because we had already produced that before. We thought it was excellent when we did it. But if it's just being produced to be produced, it's kind of a waste of effort and time. So I don't know who we would have come speak to us. I don't know who headed up this task force, but I would really love for them to come and tell us what has happened since this meeting in September, which I believe you were there.
Yes.
I just listened in on the call, but I would really like for us to have the information because I think it's good information for us to have.
Absolutely.
Thank you, sir.
Thank you. Mike Schmidt, will we be able to follow up with Vice Chair's request to have a presentation and find out where we go from here in reference to the mayor's plan?
I would suggest a couple of things with regards to that, if you would, just so that we know it's by the entire board. So if you could have a motion and from the board, and if it's approved by the board and that you believe it's a matter of great public importance to invite somebody from the mayor's task force to come and speak. If you make such a motion and it's approved, certainly we'll convey the message to somebody from the mayor's task force that they've been invited to speak at the next meeting.
Okay, thank you. I do think it's of great importance to the public, and as chair, I will be open to a motion to follow up and find the new findings, if any, where we go from here.
And before you do your motion, that was the mayor's task force, right? As I can recall. So can we go to the mayor and have someone say?
Well, I can't do this anymore. These glasses and masks. Anyway, I would put it into a motion if you'd like.
Yes, please.
Chair. I would like to move that we have a presentation in our next monthly meeting from whomever would be designated by the mayor regarding the mayor's community task force on policing and anything that has come out of that task force that would be of interest to us.
Second.
Ms. Guy has made the motion to add to the next month's agenda a presentation from the mayor's office in reference to the task force on policing. Dr. Collins has seconded the motion. Any further discussion? All in favor to add on next month's agenda on April 27th, say aye.
Aye.
All opposed say nay. In retrospect of availability as well, representative from the mayor's office, and if we can't get it into next month's meeting, we'll be open to their availability. The motion passes. If you are aware, this board is typically scheduled to meet on the fourth Tuesday of the month. The next meeting is scheduled April 27th, 2021 at 6 p.m. The public is welcome to attend our next scheduled meeting. Board members, for some reason you're unable to attend the next meeting, please notify Ms. Mercer at least 48 hours in advance so we can ensure that an alternate will be available. Are there any final comments or questions? The Citizen Review Board is now adjourned.
Taller floors, 14 feet to the ceiling of that first floor, so it's a higher, still remains